80s. We are now on the next topic, nationality and statelessness. As you know, nationality is the tie that binds an individual to his state. You determine the nationality of the person when? When do you determine the nationality of the person? Anyone? Kailan nalalaman ang citizenship or nationality?
20?
Kailan?
Kung tama po, may dalawa po. Yung isa po jus solis at yung isa po jus sanguinis po.
Hindi, ang tanong, that is the mode or the way by which you acquire nationality. Ang question is when. When do you acquire your nationality? When do you determine the nationality?
Pag pinanganak po, ma'am?
Yes. You determine the nationality at the time of birth. You see here, I'm using the word nationality. It's the more broader term that we use because later on we will discuss that you only use citizenship for states na under a democratic form of government. Because when you are in a state monarchy, you become a subject. You are not a citizen of that state. Okay, so the nationality is determined at the time of birth. Nationality is also a political term because it means the membership in a political community. A state is a political, diba? It is a community of persons, more or less numerous, occupying a certain territory. So a state is a political community and your membership to that political community is called nationality. So when you become a national of one, you become a member of a political community. Diba? As a member of a political community, you have rights and obligations. When you say rights, yan, kasama na dyan, the right to vote, the right to the privileges accorded to a citizen, katulad ng mga basic social services, diba? And obligations. Obligations includes the right and obligation to defend the state. Diba? You may be called on by the state to render military services, to defend the nation. Diba? So, like now, the state of Ukraine is on a state of war. So, the rule prohibiting all male citizens from going out of the country, that is a valid rule. You cannot go to the European Human Rights Court questioning that order prohibiting all male citizens of Ukraine from leaving the country when they are on the state of war, diba? Ang pinalabas lang doon is yung mga women and children. Because that is an obligation as member of a political community to defend. One of the important elements of state is territory. So without a territory, then you become, the state cease to exist. Okay, so you can use it interchangeably with citizenship, but yun nga, it has a more exclusive scope, yung citizenship, because it only pertains to members of state which accords more privileges to the people who owe allegiance to them. Katulad ng, Filipinos, we are called citizens because we are in a democratic state. Whereas the term subject, it has particular reference to nationals of monarchical regimes, katulad ng mga British subject. Okay, they are the nationals of the United Kingdom. And Canada, Australia, they're the subjects of the Queen. Later on, makikita niya, may example tayo sa isang case, diba? Na they swore allegiance. Those who would want to take in foreign citizenship, they will swear allegiance to that country and swear allegiance to the Queen. Okay, so how do you acquire nationality? Ito na yung binanggit kanina. You may either acquire it by jure soli o yung jus soli. Use or ang proper pronunciation ng J-U-S is use soli, or jus sanguinis or jure sanguinis. Jus soli is your citizenship is determined based on your place of birth. So, ano ba yung document na nagsasabi whether that state will be using jus soli or jus sanguinis? That document is the Constitution. So kung ano yung sinasabi ng Constitution ng bansa na mode of acquiring citizenship, yun yung masusunod. O in the case of the Philippines, we are using jus sanguinis. Whichever country you are born, if you are born to Filipino parents, then you become a Filipino citizen. Other countries use jus sanguinis or jus sanguinis, like the United States. Regardless of the nationality of your parents, if you were born in the territory of the United States, you become a US citizen. Okay, may question ba dito sa part na ito? Anything that you would like to clarify? Okay, so if you are born to and both of your parents are national of the Philippines, they're Filipino citizens, you become Filipino citizen, di ba? Regardless kung saan ka pinanganak. Sabi naman ng United States, regardless dun sa citizenship ng parents mo, for as long as you are born in the United States, you are a US citizen. So imagine a situation. Halimbawa, si A, both of his parents are Filipino citizen. He was born in the United States. Question is, ano ang nationality ni A? Anyone? So binigay kong example. Si A, both of his parents are Filipino citizens. He was born in the United States. Ano ang nationality niya?
American.
Multiple na po.
Okay. So, the right way to answer that is, in the eyes of the Philippine law, if you will be, using the Philippine laws, he is a Filipino citizen. In the eyes of the American law, he is an American citizen. So, he is actually a dual citizen. Diba? Pero pag tinanong mo whether or not he is a Filipino citizen, yes, he is a Filipino citizen. Pag tinanong mo yung US, wala siyang pakialam sa laws ng ibang bansa. As far as the US is concerned, he is a US citizen. Diba? Hindi niya sasabihin ng US na dual citizen siya kasi wala siyang karapatan to declare that that person is a national of another country. Hindi niya pwedeng sabihin na applying Philippine law, he is a dual citizen. Ang sasabihin lang ni US, he is a Filipino citizen. Ang sasabihin lang ni Philippines, he is a Filipino citizen. So si A lang ang magsasabi, I am actually applying to different laws. I am a dual citizen. If I will apply US law, I am a US citizen. If I will apply Philippine laws, I am a Filipino citizen. So, kailan lang siya pipili? At the time that he reaches the age of majority, he now has the option to choose kung ano yung kanyang citizenship. He can retain his Filipino citizenship and he can retain his American citizenship. Okay, but later on, as we discussed the Labo case, you will know that we will discuss yung tinatawag nating dual citizenship tsaka yung dual allegiance. Magkahiwalay yun. The law now, the dual citizenship law now allows dual citizenship. But as the case will discuss, dual allegiance is prohibited. Magkaiba yung dual citizenship. Yung dual citizenship is that you become a citizen of two countries because of the application of two different laws. Pero in dual allegiance is bawal yun. That is inimical to to national interest. Okay, so kapag ikaw ay Filipino citizen by birth, both of your parents are Filipino citizens, you are a natural-born Filipino citizen. Iba yung natural born citizen sa naturalized citizen. Okay? Naturalization is a process by which a foreigner acquires voluntarily or by operation of law nationality of another state. So naturalization is a process. Ina-apply ito. May proseso ito. Meron tayo naturalization law. Okay, so pwedeng direct or derivative. Yung direct naturalization is may individual proceedings, usually judicial, under a general naturalization law. O kaya naman pwedeng by special act of legislature. Usually ito yung mga ginagrant sa mga individuals who have rendered notable service to the local state. I understand during the state of the pandemic, nag-grant ang France ng nationality to all the foreigners who had rendered service, yung mga foreign, ay yung mga medical, those who are in the medical field who helped them during the pandemic, nag-grant sila ng nag-offer sila ng naturalization. So, you can do that. Nung mga state of war, ang Ukraine, nitong state of war, nag-grant siya ng special citizenship for those who would help defend the country. So, may mga ganong mga by act of legislature, you can be granted, you can be naturalized. So, third is by collective change of nationality. This is a naturalization en masse kapag nagkaroon na cession or subjugation. So, halimbawa, nabili yung isang bansa. So, like what happened to yung state of Alaska, those who would want to be American citizens, nung time ng Alaska Purchase, they'll become American citizens. And those who do not want, they have to go back to Russia para so yun, nagkaroon ng naturalization en masse after the purchase or after the cession or after the subjugation. Yung subjugation is, ayan nga, halimbawa, if Russia will be successful in taking significant part on sa eastern portion ng Ukraine, what will happen na? Kaya annex is, do they become, Russia will have to pass a legislation stating na yung na-occupy nila, they can be naturalized to Russian citizen. That's what you should do. Diba? If gusto mo talaga effective occupation ng lugar, you convert them into your citizen to become your citizen. Okay, in some cases by adoption of minors as national of the state where they are born. Okay, so ito yung tinatawag na direct naturalization when you apply or when you become naturalized by act of legislature or collective change of Pero naman tayong mga tinatawag na derivative naturalization. Para sa wife ng naturalized husband, sa mga minor children ng mga naturalized parents, or on the alien movement upon marriage to a national. Pero I have yet to check, pero walang mga bansang nag-automatic naturalization sa mga asawa. It still has to be applied. So, but siguro nung earlier days, nung hindi pa ganun ka higpit ang they are still encouraging mga immigrants. Pero ngayon, hindi na automatic yung naturalization na this is frowned upon na. Ina-apply na. Yes, Shamir?
Share ko lang po, ma'am. Sa Guam po, yung sa ganyang case, kapag po yung Filipino nag-a-apply po for naturalization doon, tapos working naman po siya, mas mabilis po siyang matanggap.
Pero hindi pa rin automatic
Apa,
diba?
May process pa rin po.
May process pa rin. So, pag magpo-fall pa rin siya under nung one na A, yung individual proceeding, pero yun, mas mabilis kapag iba yung process nila pag may asawa ka kaysa doon sa mag-a-apply ka ng wala kang asawang American citizen.
Ayun
Yeah.
po, mas mabilis po makapag-acquire ng naturalization kapag po yung single ka pa kesa po yung sa married ka na sa Philippines. Ayun po.
Oo. So ito rin kasi to discourage din kasi they know na yung ginagawa ng iba na babayaran yung American 'di ba, if you're aware dun sa On the Wings of Love na you will pay an American just so he will marry you para maging citizen siya na. They know that scheme na So mas madali pa ngayon yung mga single na magpa-naturalize kaysa sa nakapag-asawa lang. So alam ko iba rin yung visa para dun sa mga spousal visa ng mga citizen. So, yun. For those of you who are interested in migrating, so this should be of interest to you. Okay. So, kahit sa atin, yung derivative naturalization does not always follow as a matter of course kasi nga meron ng stringent restrictions kahit nga sa atin they know na kasi yung mga Americans who would want to avail of yung mga greater privileges open lang for Filipino citizens. So, ganun, gusto rin nila magpa-Filipino citizen. Anyway, okay, multiple nationality. So, sometimes talaga yan, an individual may find himself possessed of more than one nationality because of concurrent application of municipal laws. Diba sinabi ko, yung constitution ng isang bansa, yun yung nagdedetermine as to who are their citizens, di ba? Pero yung constitution, ang tawag lang dyan, municipal law lang yan kasi applicable lang yan within the territory of the state. So, municipal law yan. So, may dalawa kang municipal laws, parehong nag-a-apply sa katulad nga nito. Meron ka, sa US, they use jus soli. Sa Pilipinas, we use jus sanguinis. So, may two municipal laws. So that we apply to that individual. So meron tayong tinatawag the doctrine of indelible allegiance. So ang rito is an individual may be compelled to retain his original nationality, notwithstanding that he has already renounced or forfeited it under the laws of a second state whose nationality has acquired. Bakit nangyayari ito? Kailan nangyayari itong doctrine of indelible allegiance? Halimbawa, ito nga, yung binigyan na illustration dito is when a woman, upon marriage to a foreigner, continues to be a national of his or her own state while also acquiring her husband's nationality. So, tayo kasi, we allow this dual citizenship. So, ibig sabihin, a Filipino woman doesn't necessarily have to lose his Filipino citizenship once she acquired the nationality of her husband. Why do we allow it? Di ba may rule tayo sa taxation? Ang rule natin sa taxation is that a Filipino citizen is taxed wherever niya nakuha yung kanyang income. Wherever bansa niya na acquire yung kanyang income, she is still taxed. Katulad example ni Manny Pacquiao, may bout siya sa United States. Alam natin millions of dollars yung na kinikita niya dyan. So kahit sa United States niyan kinita, meron pa rin, he is still taxed because he is a Filipino citizen. Diba? So, I remember during the meron to parang 5 years in-implement ng Spain na you can apply for Spanish citizenship for as long as you can prove na meron kang Spanish lineage. Bakit sila nag-open ng gano'n na parang ino-open nila Spanish citizenship for so many people? That is the time, that is when the Spanish economy is so down na talagang naghahanap sila ng other sources of income. At isa sa pinakamagandang source of income for a state is yung tax from income tax ng kanyang mga citizen. So just so you know, if you apply for citizenship, you shall also, citizenship, diba, you are not only acquiring rights or privileges as a citizen, you are also acquiring obligations as a citizen. And one of the obligations of a citizen is to pay taxes. So, yun yung ano nun. So, it's good siguro na dual citizen ka. Diba? Pero if you become a dual citizen, you'll also be obligated to pay national taxes na to both countries. But you can also be asked to pay dun sa ibang bansa, sa isang bansa where you are also a citizen. So, I remember ginawa yan in Spain during the time na ng recession. So, all you have to do is to prove na meron kang Spanish lineage. At para sa atin, mga Pilipino, it's very easy, di ba? You can always find a Spanish, pakakahanap kayo sa inyong mga kalululuhan, mga Spanish decent. Okay, so if you can acquire citizenship or nationality, can you also lose it? Can you also lose your nationality? The answer is yes. It may be lost voluntarily or involuntarily. The voluntary methods of losing your nationality is when you renounce it, express or implied, or when you request for release. Diba? Usually, it precedes acquisition of a new nationality. So, ibig sabihin, makukuha mo muna isang bagong nationality bago mawala yung old nationality mo, di ba? So, when you renounce your citizenship, yan, you can acquire new citizenship. Pwede rin naman involuntary methods or when you forfeit as a result of some disqualification or prohibited act like enlistment in a foreign military, yan, continued residence in a foreign state for a long time, substitution of one nationality. You may know of Filipinos who are citizens of other countries. They are required to go back to their country from time to time. Diba? Have you heard of that? Na yung mga those who have become Japanese citizen, they have to go back to at least once a year para ma-maintain nila yung kanyang citizenship. So, because if they do not, their citizenship might be forfeited. If you are in a continued residence in a foreign country for so long. Diba? Okay. So, we have here a case. I asked you to read the Labo case. Stop this first. Did you read the cases that I sent you last night? That is an interesting case. Marami kasing diniscuss doon aside from the nationality ni Labo, which you might be interested in. Kala nyo, porket it's a 1989 and a 1992 case, wala na siyang relevance. No, it's still relevant. You will see. Okay. You know, the beauty of jurisprudence is that they are good sources of history because they are not just kwento-kwento. They're based on documents. So they cannot put in any details there that are not substantiated with facts. That is the beauty of jurisprudence. That's why these Supreme Court cases are a reliable source of history. If you would like to search on the Marcoses, you can just look at that. You can find so many interesting details. Okay. This is the first Labo case. There are two cases involving Ramon Labo and his nationality that reached the Supreme Court. This is the first case, the 1989 case. Can you see my screen?
Yes,
Yes,
okay. You can see familiar names here. Estelito Mendoza, diba? The former Solicitor General. He is the lawyer for Mr. Labo here. So, okay. I will not discuss the legal, the petition for quoranto, hindi na. Okay, yung facts na lang tayo. Okay, so si Labo, he ran for the 1989 mayoralty race in Baguio City and he won. He garnered the highest number of votes. Pero nung magde-declare na si Comelec ng kung sino yung nanalo, ipoproclaim na, pinatigil yung kanyang Actually, na-declare pa rin siya. Pero after the election, nag-file na ng co-warranto. Yung co-warranto is that it has to be filed within 10 days pagkaupo nung mayor, so nag-file ng co-warranto. Ang sole issue nila is that Labo is not qualified to run because he is not a Filipino citizen. How did he not become a Filipino citizen? Okay, so nakuha nila yung record. Merong nag-testify. Pinatawag yung pinatawag yung consul ng Australia. It would turn out ito. Si Labo was born in December 23, 1934. He was married in the Philippines to an Australian citizen. So as the spouse of an Australian citizen, hindi mo na kailangan ma-meet yung normal requirements for grant of citizenship. Pero mag-a-apply ka pa rin ng Australian citizenship. So, he was granted Australian citizenship. Before ka raw mabigyan ng Australian citizenship, you must take an oath of allegiance or make an affirmation of allegiance. Ano yung nakalagay dun sa oath of allegiance? Yan. Ganito yung nakalagay dun sa oath of allegiance for every naturalized Australian has to take. I, renouncing all other allegiance, swear by Almighty God that I will be faithful and bear true allegiance to Her Majesty Elizabeth II, Queen of Australia, her heirs and successors according to law, and that I will faithfully observe the laws of Australia and fulfill my duties as an Australian citizen. Yun yung nakalagay sa oath of allegiance. Pareho din ang nakalagay kapag ikaw ay nag-affirmation of allegiance. So, dahil nagkaroon ng Australian passport si Labo, the presumption is that he has taken the oath of allegiance. So he has renounced all other allegiance, including his allegiance to the Philippines, or to the Republic of the Philippines. Kasi he was granted He was granted the Australian passport. In fact, when he returned to the Philippines, in 1980, he was married in 1976 ata siya kinasal, di ba? Nasa na ba yun? Yung facts nakalagay, 1976 sila sa kinasal. Ayan. So, bumalik siya sa Pilipinas 1980. In fact, when he returned to the Philippines in 1980, he used that Australian passport. Kaya nga binigyan siya ng ng alien certificate registration. So, insofar as the Philippines is concerned, he is an Australian citizen and he is an alien here. Okay, so nagpa-change siya from alien certificate of registration, nagpa-change siya ng immigrant certificate of residence. So, immigrant na siya dito sa Pilipinas, hindi siya Filipino citizen. Okay, so that was in the 1980s. Tumakbo siya 1989. Walang document na sinubmit si Labo stating that he has already reacquired his Filipino citizenship. Ang sabi niya, hindi ko naman I was not automatically divested of my Filipino citizenship nung nagpakasal ako. Yes, correct. Yung marriage niya dun sa Australian does not automatically divested him with Filipino citizenship. What divested him of his Filipino citizenship is when he renounced his Filipino citizenship and he swore allegiance to Australian government. Diba? He became a citizen of Australia because he was naturalized. And to be naturalized, he has to go through the formal and positive process. Ito yung sinasabi. Diba? Hindi yung marriage niya yung nagpa-revoke ng kanyang citizenship, Filipino citizenship. It was when he renounced all other allegiance and he swore to be faithful to Queen Elizabeth II, the Queen of Australia, and to fulfill all his duties as an Australian citizen. So yun. So ang sinabi, no, wala kang sinubmit ng any document. Chinek nila with the Commission on Immigration and Deportation, wala siyang application na reacquiring his Filipino citizenship. And what does the law say? Can he run as mayor of Baguio? The answer is no. Ang nakalagay sa Local Government Code, Section 42, an elected official must be a citizen of the Philippines, at least 23 years of age on the day of the election, a qualified voter, registered as such. In fact, pati nga yung kanyang pagiging registered voter was questioned here because you can only be a voter if you are a citizen of the Philippines. You cannot vote if you are not. So even his being a registered voter was questioned in this case. So now that there was already a ruling that he could not run, then all the votes casted on him is invalidated. So ang kalawan niya rito, di ba, the person who got the second highest number of votes. Pero sabi ng court na even if Labo was disqualified, the person who got the second highest number of votes will still not be proclaimed as the mayor. Diba? Why? Because the sound public policy dictates that public elected office are filled by those who have received the highest number of votes cast in the election, and it is the fundamental idea in all Republican forms of government that no one can be declared elected and no measure can be declared carried unless he or she receives a majority or plurality of the legal votes. The side fact is that ang sinabi pa doon sa isang case, he was repudiated. The person who got the second high was repudiated by the people. So he will still not be, So who becomes the mayor of Baguio now? The mayor of Baguio is the vice mayor, the duly elected vice mayor. He shall now become the mayor of Baguio City. That was in 1989. Okay. What happens to the next case? Can you see my screen? Reflected na ba yan? Stop ko nga muna. Baka hindi nagpapakita ng maayos. That was in 1989. Di ba 3 years ang term ng mayor?
3 years
So,
po.
3 years ang term ng mayor, di ba? Matatapos 1989, matatapos ng 1992. So magkakaroon ng election ng 1992. Tatakbo ulit si Labo. And for the second time, he will win. He will get the highest number of votes in mayoralty race. Talo niya yung isang bagong tumakbo, si Ortega. Ayun, lumabas na naman yung issue ng citizenship ni Labo. Ang sabi ng Supreme Court, ganun pa rin. He is still disqualified. This time naman, ang nangyari lang is that meron na siyang application ngayon sa application for to be naturalized. Pero, nung time na tumakbo siya, noong 1992, hindi pa rin lumalabas yung kanyang yung decision sa kanyang application despite the positive recommendation of the Office of the Solicitor General, hindi pa rin lumalabas yung decision ng what office is that? Ayan. Sabi ng to this day, despite favorable recommendation by the Special Committee of Naturalization had yet acted upon his application for repatriation. So hindi pa rin siya naturalized nung time na when he applied for Philippine citizenship. So he has not yet reacquired his Philippine citizenship. So, halawang beses na nanalo. So, and just like in the case in 1989, who would get to sit as the mayor, it is still the vice mayor. Sabi, di maganda yung ginamit dito. Yan. It is therefore incorrect to argue that since the candidate has been disqualified, the votes intended for the disqualified candidate should, in effect, considered be null and void. This would amount to disenfranchising the electorate to whom sovereignty resides. At the risk of being repetitious, the people of City of Baguio opted to elect Petitioner Labo bona fide without any intention to misapply their franchise and in the honest belief that Labo was then qualified. Unfortunately, Labo turned out to be disqualified and cannot assume office. So, the ineligibility of the candidate receiving majority does not entitle the eligible candidate receiving the next highest number of votes to be declared elected. So again, the vice mayor shall assume the mayoralty of This time, ang vice mayor nito is si Dumogon. Tapos the next time that he will matatalo na siya, Dumogon is a very popular. He will finish 3 terms and then run again and finish another 3 terms. So that is how that is the sad fate of Mayor Labo. He was a mayor for months. If you will search or if you will look into the history of Baguio, he will serve as mayor parang like 2 months lang in 1989, then 2 months again in 1992. So that's the sad unfortunately, the people of Baguio really likes him. The fact that he was elected twice, he won the highest number of votes twice, meaning the people of Baguio really likes him. It's just that Yes, Shamir, you have question?
Bali po ma'am, tanong ko lang po, kapag po ganun yung case na yung vice mayor po yung nagiging mayor, paano po yung magiging process po sa magiging vice mayor niya po during that term?
Okay. So under the local government code, meron tayong tinatawag na rules of succession. So the rules of succession is that the highest, the sangguniang bayan, city, sangguniang panlunsod, the number 1 member of the sangguniang panlunsod. Yeah. So yun yung magiging vice mayor. Yes, John.
Aslam po. Wala po bang power yung COMELEC, ma'am, na mag-filter nung mga candidates about dun sa upon filing COCs po? Kung sino po yung qualified?
Actually, kaya nga itong mga cases na to kasi, these are filed with the COMELEC. Hindi naman ito aabot sa Supreme Court direkta eh. So these are filed with the COMELEC, so may mga decision yung COMELEC and then ina-appeal hanggang it reaches the Supreme Court. So, like the case of Labo, he was already disqualified by the COMELEC. It's just that after na nila makapag-proclaim ay ina-appeal. Hindi sila happy with the decision. Okay? Bantugan?
Hello po, narinig po?
Yes?
Siguro ma'am, reaction lang din po na ito po siguro ay bahagi ng kahinaan din po ng sistema na meron tayo. Kasi po, if I'm not mistaken, si Edu Manzano po, noong 90s naging vice mayor na, and then in 2010 naging vice presidential candidate. And yet, noong 2019 elections po, na-disqualify siya as representative of San Juan dahil din po sa issue ng citizenship. So, kung titingnan, parang ang daming beses na po siya na nag-participate sa election, pero yun din pala po yung magiging butas sa recent time lang na sumali ulit siya sa election. Thank you po.
Yeah, di ba? Minsan pinalalampas nila kasi hindi pa naman inconsequential yung mga positions, di ba? Tapos, yun ba, nung vice president, inano siya kasi there's no chance of him winning. So, pero meron ng may decision ng Supreme Court dyan sa kaso ni Edu Manzano. And hanapin natin yung decision. They're just bringing the cases again and again kasi parang to distract that person from So ito yung case niya in when he was running as vice mayor ng Makati yata to. Yan. Ernesto Mercado, yan. Versus Eduardo Manzano and Comelec. So, yeah. Si Edu Manzano kasi was, diba, both of his parents are Filipino citizens, but he was born in the United States. So, Vice Mayor of the City of Makati in 1990 election. So, let's just go to the, So, ang nangyari sa kanya, diba, unlike Labo, na he has to renounce his Filipino citizenship for him to become an Australian citizen, si Edu Manzano is the classic case. Yung katulad ng binigay na natin kanina na he just become an American citizen because of the application of two laws. Diba? He became a dual citizen because of the application of two different laws. In the eyes of the Philippine law, he is a Filipino citizen because both of his parents are Filipino citizen. In the eyes of the American law, he is an American citizen because he was born in the United States. So he doesn't have to take allegiance to the United States for him to acquire Filipino citizenship. At the time, American citizenship, because at the time of his birth, he has acquired. Pero yun nga, sinabi dito ng Supreme Court, by declaring a certificate of candidacy, kasi sa certificate of candidacy, meron ka diyang ilalagay na you are a permanent resident, you are not a permanent resident or immigrant of another country, you will defend and support the Constitution and bear true allegiance, you will defend the Filipino, yan. So, in effect, that repudiated daw his American citizenship. So, sinasabi ng dito, what differentiates those who become dual citizen by birth, yung just by being born, is that you don't have to take oath pa for you to it is enough that you file your certificate of candidacy, and that is an automatic repudiation of your American citizenship. So by the time that he filed his residency, his certificate of candidacy, he has already renounced his American citizenship. He ceases to become a dual citizen. So na-dismiss dito yung petition against him. Sinustain yung kanyang pagiging Filipino citizenship. Okay, so na yan. Kaya lang they will bring up the case over and over again because yun nga, para to distract him lang and to Another good case is the case of Grace Poe. This is a classic case then because unlike naman others, Grace Poe is a foundling, di ba? So, di ba, sabi natin, ang citizenship is determined at the time of birth. So, paano yung, because we are under Filipino, under the Philippine law, the nationality, we follow the jus sanguinis, so you have to determine the nationality of the parents for you to know the nationality of the child. So, paano yung case ng mga foundlings? Because you don't know the nationality of the parents. So, ano yung nationality ng mga foundling? A foundling, you do not know your parents, di ba? So, ano nationality ng foundlings? So, yun yung sinagot sa case ni Grace Poe. Yung origin of petition, nag-file ng questioning her certificate of candidacy because it stated there that there was a material misrepresentation because she is not a natural-born Filipino citizen because actually, dalawang issue dito sa kaso ni Grace Poe. One is her citizenship and the other is her residency. I believe that tama yung decision as regards her citizenship. That a foundling should be considered as a national of a country where she or he was found. Diba? Because their foundling, it's impossible to determine their parents, so they should have been considered as a national of the place where they are found. Pero I think nagkamali dun sa issue ng kanyang residency. Dapat na-disqualify pa rin siya on the basis of the residency. Anyway, so yun lang ang importante dito na sabay sinabi ng Supreme Court doon. May press ka pa. Ano? Okay. So, cite natin itong maganda itong argument na ang ginamit na in determining the nationality of the foundlings. They use the United Nations Declaration on Human Rights, United Nations Convention on Civil and Political Rights, which obligates the Philippines to grant nationality from birth to ensure that no child is stateless. Diba? So yun yung ginamit dito. The grant of nationality must be at the time of the birth. So it is incongruous for a state to find pa the parents before they could grant. So a child whose parents are both unknown shall have the nationality of the country of birth. And the fact that she is found here in the Philippines, it presupposes that she was born here. So yun yung ano nila dito. So a foundling found in the territory of the contracting state shall, in the absence of proof to the contrary, shall be considered to have been born within the territory of the parents possessing the nationality of the state. So ang ginamit na basis talaga in upholding the nationality of race po is the International Convention on Civil and Political Rights and the United Nations Declaration of Human Rights, which is beautiful actually. If you will just read the decision on these portions, the decision is very beautiful in such that it upheld talaga the rights of the foundlings. So yan, maganda tong discussion on civil and political rights. Okay, so let's go back to our discussion. Okay, so conflict of nationality laws. To provide against conflicts arising from divergent municipal laws, the following rules were embodied in the Hague Convention of the 1913 of Conflict of National Laws. So, under Article 1, it is for each state to determine under its law who are the nationals. So, it is the Constitution that dictates who are the national of the state. And these laws shall be recognized by other states insofar as it is consistent with international conventions. So any question as to whether a person possesses the nationality of a particular state shall be determined in accordance with the law of the state. Subject to the provisions of the present convention, a person having two or more nationalities may be regarded as the national by each of the state whose nationality he possesses. So katulad nun, sabi ko nga, a dual citizen, as far as yung two countries are concerned, they both acknowledges him as a national of their state. So he possesses all the rights as well as the obligation as a national of that state. A state may not afford diplomatic protection to one of its nationals against a state whose nationality such person also possesses. Ibig sabihin, okay, this happens kapag merong mga cases that you bring to the international courts. So kapag ang conflict arose between two persons who are both nationals of the same state, hindi pwedeng kunin ng isang state yung side ng isa lang. Diba? Against its own national. So kapag ganon, the matter should not be brought to the international court and the matter should be resolved within the state where both are citizen. Within a third state, a person having more than one nationality shall be treated as if he had only one, without prejudice to the application of its laws in matters of personal status. On any convention in force, a third state shall, of the nationalities which any of such person possesses, recognize exclusively in its territory. So a person who is carrying who is a dual citizen, as far as the third state is concerned, he should be treated as a national of only one state. Diba? Malinaw ba yung part na yon? Halimbawa, Edo Manzano, dual citizen of Philippines and the United States, as far as Italy is concerned, a third state, he can treat Edo Manzano either as a Filipino citizen or an American citizen only. Diba? Okay. Article 6, without prejudice to the liberty of the state to accord wider rights to renounce its nationality, a person possessing two nationalities acquired without any voluntary act on his part may renounce one of them with the authorization of the state whose nationality he desires to surrender. The authorization may not be refused in the case of a person who has his habitual and principal residence abroad. Okay, so let's study the case of Canevaro. This was brought to the Permanent Court of Arbitration in 1912. Okay, the question that was brought was whether Italy may file a diplomatic claim against Peru on behalf of Rafael Canevaro, who is a national of both states under their respective municipal laws. So, bakit Peru versus Italy? Kasi si Rafael Canevaro is a Peruvian by birth. He was born in Peruvian territory. On the other hand, according to an Italian legislation, he is an Italian nationality because he was born of Italian father. Because according to the Italian law, if you are born to either parents mo is an Italian, you are also an Italian citizen. For several occasions, Rafael acted as a Peruvian citizen. In fact, he ran for the Senate. He had been practicing yung rights as a Peruvian citizen. He defended his election several times, particularly by accepting the office of the Consular General for the Netherlands after having secured authorization from both Peruvian government and Peruvian Congress. So, dito nag-a-apply yung concept of indelible allegiance, doctrine of indelible allegiance na even despite the fact that the Italian law recognizes him as an Italian citizen, but also his life he has been practicing as a Peruvian citizen, then the Italy cannot file diplomatic claim against Peru on behalf of Canevaro because he has never exercised any right as a citizen of Italy. All his life he has been and has always been a Peruvian. He was born there. He has acquired positions in the government of Peru, has always which are reserved only for Peruvian citizen. So his status as an Italian citizen was denied by the arbitration court. There's another case. Ito namang Notenbaum case. Si Notenbaum naman, he was a German by birth, but he has been a resident of Guatemala for 34 years when he applied for and acquired naturalization in Liechtenstein. 1 month before the outbreak of World War II, member of his family's and his business connections were in Germany. In 1943, Guatemala, which had declared war on Germany, confiscated all his properties on the group that he was on the ground that he was an enemy national. Liechtenstein thereupon filed a suit against Guatemala on his behalf as a natural citizen. So, nakikita niyo yung picture? A war is between Guatemala and Germany. Si Notenbaum until 1 month ago was a citizen of Germany. Ano ang decision ng ng court dito? Was Notenbaum's naturalization in Liechtenstein binding on Guatemala? The court said the court of third state when they have before them an individual whom 2 other states hold to be their national seek to resolve the conflict by having recourse to international criteria, and their prevailing tendency is to prefer the real and effective nationality. So, tinignan nila yung actual connection with Liechtenstein, which is extremely tenuous. Diba? So, not until 1 month ago, he was a German citizen. So, mukha talagang sinadya lang niyang mag-apply na citizen ng Liechtenstein to avoid yung confiscation ng kanyang property as a national of an enemy state. So, ang sabi rito, Guatemala is under no obligation to recognize a nationality granted in such circumstance. So, Liechtenstein consequently is not entitled to extend its protection to Notenbom. Kapag nasa state of war, hindi lang kino-confiscate yung enemy, yung property ng enemy state, kundi pati property ng mga nationals of that enemy state. So, yun yung nakakatakot kapag nagkakaroon ng state of war. Especially if you have properties on the state where your country has declared a state of war. Okay, so now, statelessness. So kanina sinabi natin, pwedeng magkaroon ng pwede ka mag-acquire ng nationality, pwede ka mo ring ma-lose yung nationality mo, di ba? So kapag nag-acquire, na-lose mo yung citizenship without acquiring a new one, then you become stateless. So stateless is the condition or status of individual who is born without any nationality or who loses his nationality without retaining or acquiring another. So an example, a child born in a state where only jus sanguinis is recognized to parents whose state observes only jus soli. Tingnan nyo yun. What if you are born on a state where only jus sanguinis is recognized? Tapos naman, yung parents mo naman, they're born on they are nationality of a state who only uses jus soli. Kaya nagkaroon ng provision na ganito sa United Nations Convention on Civil and Political Rights to avoid statelessness. No child should be a victim of contradicting rules. Diba? So under the United Nations Convention on Civil and Political Rights, which I have shown you kanina, stop natin to para mapakita ko ulit. Doon sa kaso ni Grace po, ang rule under the United Nations, yan. Sa United Nations Convention on the Rights of the Child, ang nakalagay is that the child shall be registered immediately after birth and shall have the right from the birth to a name, the right to acquire nationality, and as far as possible, the right to know and to be cared of by his or her parents. So state parties shall ensure implementation of these rights in accordance with their national law and their obligations under the relevant international instrument in this field. So another provision is CPR, which states that every child shall have, without any discrimination as to race, color, sex, language, such measures of protection as are required by his status as a minor on the part of the family, society, and the state. And every child shall be registered immediately after birth and shall have the name. Every child shall have the right to acquire a nationality. So, all signatories to the International Convention on the Civil and Political Rights, they must make a measure to ensure that every child born within their territory must be given nationality, or at least a provisional nationality until they reach the age of majority. So until they are on the age of minority, they shall have yung tinatawag natin mga provisional citizenship. Kasi nga, ang purpose talaga nito is so that every child shall have a state that will protect that child. Kaya talagang yung ginawa ni Trump of removing the parents from their mother, yung those who were born dun sa mga from illegal immigrants, mga born in the United States that should have been accorded na American citizenship. And so talagang maling-mali yun in the eyes of the international law. Okay, so I think matatake natin. Okay, so next is treatment. Sino ba yung mga aliens? Anyone na pumasok dito sa Pilipinas who are not citizen of the state are considered aliens. So, ang rule is that settled that every state has the right as inherent sovereignty and essential to its own security and existence to determine in what cases and under what conditions should foreigners be admitted to their territory. Ito yung reason kung bakit nagre-require ng mga visa. Kasi ito yung mga conditions sila before foreigners may be admitted to the territory. So, those who applies for visa, meron ng unwritten rule that they will follow all the laws of the state and they should be aware of the law in the states. Diba? Because the rule is that when in Rome, you do as the Romans do. Yun lang naman ang the better way to put it. So hindi mo pwedeng idahilan na you don't know the rules because you have an obligation to know the rules before coming to that country. Okay, and rules sa alien is that in case of any violation committed by an alien, you have to notify the state where that alien belongs or where that alien is a national of. So, meron tayong tinatawag na doctrine of state responsibility. Under this doctrine, a state may be held responsible for an international delinquency indirectly or directly imputable to it which causes injury to the national of another state. So, that is why mahigpit tayo. We are so strict in accepting foreigners because of this liability. We have the liability to treat aliens according to the international standard of justice. And if we become remiss, then we may be held accountable because of the doctrine of state responsibility. So, international standard of justice. In case of failure to protect the aliens or to address the grievances of an alien, we may be held accountable. Meron tayong case ng Shatin. Nakalagay doon yung standard of justice that is required in the treatment of alien. Hindi ko pala naisama yung point. Okay, so ang nakalagay lang doon is dapat from the time of the investigation, pati dun sa hearing, dapat nagkaroon ng opportunity dapat inform yung state na merong isang citizen that is being tried. Dapat inform siya from the start of the proceeding up to the end. And no judgment against the alien will be legal unless the state was notified of the proceeding. So yun yung essence lang naman ng Shatin case. Ano pang isa? Okay, exhaustion of local remedies. Before assuming the liability of the state for international delinquency, dapat daw i-exhaust muna yung mga local remedies. So mag-file ka muna ng claim dun sa states. At kapag hindi na ng state, then you bring the matter to the international court. Resort to diplomatic protection. If the injured foreigner has exhausted all local remedies but without success, then he may avail of himself of the assistance of his state, but only if he has a state. So if he has no party to represent he by himself or being a mere individual, he cannot institute his claim in his own name. Kasi ang nakalagay, di ba, sa international court, sino lang pwede magbigay ng claim? Sino lang pwede mag-lodge ng claim? State. So kailangan i-bring ng state mo yung action on your behalf because a person cannot be a subject of an international law, only the state. Okay. Avoidance of state responsibilities. Exclusion of aliens. Aliens may be excluded by extradition or deportation. So, ano pagkakaiba ng extradition? Extradition is, okay, wala yung summary rito. Sige. Okay, ano pagkakaiba ng extradition and deportation? Sa extradition, yung crime was committed sa ibang bansa. At yung taong nakakommit ng crime ay nasa Philippine territory. Okay? So, yung ibang bansa where that crime was committed, he wanted that person to be deported back to that country, to be extradited to that country so that he could face penalty there. Yun yung ng extradition. So vice versa, halimbawa that yung criminal was in another state, the crime was committed here in the Philippines, we wanted that person to go back here so that he could face the criminal liability. Ganun yun. So yun yung extradition. For an extradition to be valid, dapat meron muna extradition treaty. So, meron muna dapat extradition law, may treaty with another state na providing for extradition. So, kung walang extradition treaty yung bansa na yon with the Philippines, then we can just ignore their request. Kasi wala magiging basis yung extradition. So, the same is true doon sa ibang bansa. Kung wala tayong extradition treaty with them, then they will just walang magiging basis yung request natin for that person to be extradited back. So, dapat merong treaty. Kaya naalala nyo yung time na si Gloria Macapagal-Arroyo would want to go para daw for magpagamot sa isang bansa, and then when they check, walang extradition treaty doon yung Pilipinas. They denied the request of President Gloria Macapagal-Arroyo because they know it. That the moment that she went out of the country, we do not have extradition. If she refuses to go back, then she can just abscond. Diba? She can just, Okay, so another requirement aside from that there must be an extradition treaty is that there's yung tinatawag nating speciality, principle of speciality. Okay? So under the principle of speciality, dapat yung state requesting extradition from another state is required to specify the crime as provided in the extradition treaty. At dapat, yung crime na yon ay nakalista dun sa mga crimes na nilagay natin when extradition will be applicable. So pag hindi natin nilagay yung crime na hindi natin in-specify yung crime, at yung crime na yon ay wala dun sa list kung saan applicable extradition, then it will also be denied. Okay, meron tayong tinatawag sa treaty natin between the Philippines and Thailand. Meron dyan provision under Article 9, a general rule, a person extradited shall not be prosecuted, sentenced, or detained for any crime committed prior to his surrender other than that for which he was extradited. So, ito yung sample ng mga speciality. Dapat may mga provisions na ganyan na itatry ka lang for the case to which you are extradited. Plus, yung requirement din, double criminality rule. Ang dapat yung crime for which you are being extradited must also be recognized as a crime dun sa bansa where you are requesting it. So, dapat it is recognized as a crime by both the requesting state and the state where you are seeking extradition. Halimbawa, murder should be both punishable halimbawa sa state A at sa state B. Okay? So, kapag hindi siya punishable dun sa state B, then hindi mo pwedeng gamitin yung extradition. Nagkaroon na ito ng kaso, pwede ba rin yung bail? Pwede bang i-grant yung bail sa extradition treaty? So, sabi, possible, pwede pa rin. Basta he will not be a flight risk or a danger to the community and there exists a special humanitarian compelling reasons. Okay, we no need to discuss the procedure of extradition. So, deportation naman, yung deportation is that when an alien commits a crime, dun sa foreign country, then he will be deported back to his state. Ganun lang yun. Obligations, erga omnes. Okay, I'll stop here. Sabi ko hanggang citizenship lang tayo. We will start with obligations erga omnes on our next meeting. Page 66 na tayo. Okay, kids, we will only have one more meeting and then end na ng semester. Okay? Yes, yun pa yung kaya sinasabi ko, di ba, yung kaso ni Labo is still relevant because i-apply din yun. Na iba yung kaso kung na-disqualify supposedly si Marcos before the election and it has been publicized, pero ito nga yung isang kaso ng question ni Taoy kasi if mawala ng visa yung pagkapanalo ni Marcos, meaning niya siguro dito if Marcos is disqualified. Kasi di ba meron pang pending disqualification case on Marcos? The Supreme Court declares that Marcos is disqualified because of the tax evasion case. Si Duterte po ang magpapalit sa kanya, yes. If you understand the case of Labo, yun yung sinasabi ni ano dun sa case ni Labo, ni Supreme Court dun sa case ni Labo. Nang sabi niya, stop share ko na. There's no way that second highest, it's different if if the people has been informed that he was disqualified and they still voted for him, then all the votes casted on him should have been invalidated. Diba? But during the May 9 by election, during the May 9 election, there's still no decision na sinasabing he is not disqualified to run. Then the people thought he was disqualified to run. That's why they voted for him. So, yun. Maganda yung sinabi ng court dito. Parang, ayun. Ito. Yan. He was repudiated by the electorate. What matters is that in the event a candidate of an elected decision is voted for and obtains the highest but is disqualified for not possessing the eligibility, the candidate who obtains the second number cannot assume the vacated. It would have been different. It would have been different if the rules would have been different if the electorate were fully aware in fact and in law of a candidate's disqualification supposed to bring such awareness within the realm of notoriety would nonetheless cast their votes in favor of an ineligible candidate. In such case, the electorate may have said to have weighed the validity and efficacy of their votes by notoriously misapplying their franchise or throwing away their votes, in which case the eligible candidate obtaining the next highest number of votes may be deemed elected. So dapat magkaroon pa rin ng degree of notoriety. So the people should have been made informed that he was disqualified and then they still voted for him. Then the person who has next higher number of votes will be deemed elected. Because those who voted for an ineligible candidate will be deemed to have waived their right and threw away their votes. So, yun yung isang beauty nitong case na to. That's why these cases are still good and they're still irrelevant despite the fact that na 1989 and 1992 cases to, because you can still find relevance sa mga kaso nito. Okay. May questions pa? May magtatanong pa? Okay, kung wala na, may mga pumasok pa ba? 3-1?